Good afternoon. My name is Antonio Sperlin. I am delighted to be a co host today with you on this live restream video. Today, we're going to talk about various sundry legal matters in the area of family law related to domestic relations, child custody, support, child support, bankruptcy, divorce, alimony, and just general family law. So we are delighted and excited that you've taken this time to join us. And on behalf of Pastors George and Judith Matthews, we want to thank you for having the vision and the insight to put together these types of forums. I think they're of vital importance and benefit to both our listening audience as well as to us as professionals to have the opportunity to express from a professional disposition questions and to provide answers rather to your questions. So we are truly excited that you've taken this time to be with us today. At this time also, we have as a co-host, we have attorney Danetta Washington, and we have Ezra Jordan as well will be joining us very soon. And so I'm excited that you've taken this time out to be with us. I see individuals are logging on, and questions I'm sure will be forthcoming in just one moment's time. And so while you're with us today, please feel free to send this link to your friends, relatives, co-workers, and others, and let them know that New Life Interfaith Ministries, in conjunction with Calvary Resurrection Christian Church, are providing a legal forum today for you to log on and to ask questions that concern the areas of family law today for this segment in time by which we'll be together for the next 40 plus minutes. It only is appropriate to express our appreciation and gratitude as professionals for having a forum to engage you in this type of platform for a period of time. And so we are honored to share with you in this particular manner, and we are truly grateful. And we are truly ready to go. So we're geared up. Awesome. Thank you so much. And so here we have the incomparable Danetta Washington with us, and then we're also flanked by Mr. Uh, Ezra Jordan the third. He's a great attorney here as well, and so we're delighted to have these two highly esteemed, highly acclaimed professionals practicing in the great state of Alabama. And so we're delighted to have them join with us today. And so if you would, before we get started, Attorney Washington, if you would share with the listening audience, ladies first, of course, the areas of practice that you practice law in.
Absolutely. First of all, thank you for having me.
Thank you for coming.
But yes, thank you for having me. I own Washington Law. I'm in private practice, and the areas of law that I practice in are mostly family law. It includes divorce, it includes custody and child support, and I also do a little bit of what we call dependency cases. And those cases involve DHR. My firm also specializes in estates and then some personal injury as well, but the bulk is family law.
That's awesome. Well, thank you so much for sharing with us the primary areas of your concentration. And we have also Attorney Ezra Jordan the third. Hello, sir. How are you?
I'm doing well. Hello, everyone. Thanks for the opportunity to share. I own Jordan Law Firm, and I also practice in the areas of family law, divorce, alimony, child support, dependency cases. We're a full service law firm, and we have many areas that we practice, which include criminal defense, and we represent some companies and corporations and things like that. But my uh, passion is with family law and domestic relations issues. So again, thanks for allowing me to share.
Well, thank you so much for joining us. And so we'll just get ready to jump right in. I see a comment from someone speaking in terms of his lovely wife, and so that's a very close, dear friend of mine, Mr. Trey Washington. So we're glad to have you joining in and participating, Mr. Washington. And so, with that having been said, we are now open for questions concerning family law. Yesterday, we had the opportunity to have the Honorable Shantae Brown. We say that she's honorable because we're by faith believing she's going to win the position of district court judge in the Bessemer cutoff. And so we're so excited to know that she is aspiring for that particular rank and file as far as office. And so we are truly praying and encouraging her. She's one of New Life's very own, so we really want to be in support of her, along with our Calvary Christian Church campus family as well. So, with that having been said, if you have questions, I want to encourage you to submit those questions. I, as the co-host or host, will provide uh, a clarification of what the question is, and either of the attorneys are more than welcome to answer those questions. And then I will also chime in from time to time, but I'm sort of the backseat driver, so to speak. So I'm excited. This is day 3, and we've had some awesome participation in the preceding 2 days, and I would expect none less from this particular audience that appears to be logging on. And so we'll be here live for the next 39 minutes and 27 seconds, roughly 40 minutes to go. So with that having been said, please feel free to ask your questions. And we will go from there. As lawyers, we have a tendency, because we don't sell widgets or whatnots, our words and our conversations are our inventory. So we will talk into infinity as long as you're paying. But in this setting, we are not seeking compensation. We're just trying to provide a service in all seriousness, but we want to answer your questions. So feel free to send us your questions, and we will provide answers to those questions. So with that having been said, I'm seeing a lot of amens and good afternoon, but let's get to these questions. Yes. All right. Maybe we'll have some questions generated after we discuss some areas of domestic relations. Attorney Washington, share with us some of your understanding in the area of child custody and child support, and how that interfaces with a divorce, and if that is required, that if a child is uh, born of a marriage or not born of a marriage, if you will, would there be a need to include child support in a divorce decree?
Um, so that's a loaded question. I'm gonna try to make it as concise as I possibly can. But in regards to a divorce, if there are children born of the marriage, the first thing is that there's a presumption that the father or the husband is the legal father of that child, and so the divorce court has jurisdiction to enter an order of child support. They have an obligation to address the issues of support as well as the issues of custody and or visitation. If a child is not born of a marriage, what has to happen is a petition would have to be filed with the district court or family district court. And that petition for either support and or custody can be filed by either parent. Now, in regards to the support part of it, most of the time those petitions are filed by the mother. And that petition is most of the time filed against the father. As it relates to custody in family court, you can only the court is only going to address one issue at a time, meaning if somebody files a petition for support, the judge is not going to address the issues of custody or visitation unless a separate action is filed before the court. They're only going to address that one issue at a time. And then again, going back to the divorce proceedings, if a child is born during a marriage, the circuit court has an obligation to address both the support as well as the visitation, but is not required in family court. You have to file separate actions for support and for custody or visitation if the parties were not married at the time that the child was born.
1207. What is the statute of limitation to collect property from a divorce?
I'll answer that.
Okay.
So if a divorce decree has been entered and a property award has been given to a particular party, for example, if a wife is awarded a house or some money as in alimony and gross or some other item, that order is presumed to be valid forever. So if those items are available or have been disposed, then that person can seek some relief from the court to enforce that order. So even if the person has divested themselves of those items. So in my example, say the wife was ordered the sum of $20,000 out of the husband's IRA. And the husband, subsequent to that order, took the money out of the IRA and spent it. Just because the money has been spent doesn't absolve him from the obligation to pay it, and it doesn't mean that the wife in this example can't request from the court that the husband be required to pay that money regardless of the fact that he divested himself of it. And he can be held in contempt of court for violating that order and forced or compelled by the restraints of the court to have to comply with the property award.
Very good. And this question came in at 12:08, and I think it falls right within the purview of what you just stated, Attorney Jordan. And the question reads: After a court order has been implemented for child support, what can the custodial parent do to enforce the order after consistent non-payment? And I think you've pretty much touched on that, but if you'd like to elaborate on that briefly further, you or Attorney Washington, feel free to jump in there.
I'll just finish it up. So on the Rule 9 side, which is also what we call a contempt petition, the first question I ask my client when they want to do something like this is, what did the order say? And what is this person doing or not doing that's inconsistent with the order? Because that's where it really begins. So if this person is consistently not paying child support or consistently doing something that they have been specifically ordered not to do, then that is a violation of the court order. And the proper thing to do is file a petition for Rule 9 or contempt with the proper court.
Okay, very good. And so, also with regards to the subject of bankruptcy, and we will vary in between these subtopics. And I understand that some of you have some experience with regards to bankruptcy. Is that correct?
I do.
Right. And so, what's the difference between a Chapter 7 and a Chapter 13? Share that with our listening audience because that may generate questions as well.
You want to do it, Ms. Washington? You want me to answer?
Oh, you can go ahead, Attorney Jordan.
Okay. So a Chapter 7 is what some people call a wipe away bankruptcy. It's where you take all of your assets, place them into the estate, and ask the court to absolve you of all your responsibility on debts, except for those things that are specifically excluded by the United States Bankruptcy Code. So a person has a bunch of credit card debt, they had a car repossessed, and they don't want to pay those debts. So they file a Chapter 7 bankruptcy petition and say they have a home that they are paying the note on that is not worth above a specific amount. Then they're able to file the Chapter 7 bankruptcy, maintain the house, and get rid of the credit card debt and perhaps the debt that's associated with the car that was repossessed. A Chapter 13 debt is what people call debtor's court. In that chapter of bankruptcy, the debts are placed into what we call a plan. So if the person has $100,000 worth of debt, that debt has to be paid off generally under rules in 5 years. And so payments are made systematically every month for 5 years until discharge. Generally, those types of petitions are filed when a person's in danger of A, being evicted or foreclosing their home, or they're about to lose a fixed asset or a semi-fixed asset like a car. The car is about to be repossessed. Say, for example, they owe $10,000 a month and their note is like $900. Well, if we take that $10,000 and put it into a Chapter 13 plan and spread it out over 5 years, then the note would not be 900, it would be significantly less, which would allow this person to maintain their property. In general, that's the difference between the two.
It's very good. Attorney Washington, you have anything you'd like to add to those statements and differential between a Chapter 7 or a Chapter 13?
No, not really. What I would say is that it's been my experience that with bankruptcy, it can affect a request for alimony in the divorce proceedings, depending on when a person has filed for bankruptcy, what stage they are in the bankruptcy. And so it just affects the incomes of the parties, particularly the person that is in bankruptcy versus the person that is requesting alimony. from that individual that's in bankruptcy. So it can affect a divorce proceedings just depending on which chapter you filed and then where you are in the process of that chapter as well.
Here's a question, and I've been asked this several times, but I think it would be a good plug to put into this particular segment. Can you bankrupt child support
No,
arrears?
no. So in the bankruptcy code, there's a provision that says that there are what we call domestic support obligations. And the United States Bankruptcy Code, in the discharge section, specifically excludes DSOs or domestic support obligations for being discharged. So your child support or alimony money is with you like Gucci luggage. You never get rid of it. You have to pay it and you keep it forever.
So Kanye West has a serious challenge on his hands if he's not fulfilling his obligation. Uh,
Exactly.
and also, can you bankrupt uh, taxes?
Very rare occasions can you? I mean, very, very rare. And I don't think we have time to distinguish between that. I would just go out to say most often the answer is going to be no.
Right. And can you bankrupt student loans?
The same is the same. That's some really like really, really, really old loans. And every time that I've seen it done, the person has been an extremely senior citizen, and those loans were had a long time ago, and most of it's all interest, and there's also some concessions made by the federal government to allow it to happen as well.
Okay, exactly. Here's a question, which is a great one. It says, when is it just for a judge to take the custody of a child away from the biological father and give that custody to another man who is not the biological father?
That's a loaded question. It's a very loaded question. And I think I would say you have to look at the totality of the circumstances, whether or not the bio dad is adjudicated as the legal father. One would depend on whether or not the parties were married. Again, there is a presumption in Alabama that if parties are married and a child is born of that marriage, that man is going to be presumed the father. And it's very hard to rebut that presumption in Alabama because Alabama doesn't like to bastardize a child. And so it's a very loaded question. But again, a judge is going to look at the totality of the circumstances. The only way under that presumption in regards to a husband being deemed the father of a child is you're going to have to present some form of scientific evidence, DNA evidence that he is not the biological father of that child. Again, as far as the judge is concerned, it just is based on the circumstances and the totality of those circumstances and facts. But more so in regards to a marriage, again, there is that presumption that if a child is born of a marriage, then that man is deemed the father of that child. Attorney Jordan, did you want to add anything?
Well, to me, I mean, I'm just trying to read between the lines of the question.
Mhm.
When when you say take custody of a child away from the biological father, I'm assuming that the father has legal custody of some sort, either through the marriage or through the family court, through a child support paternity action. And in that instance, I can't think of very many reasons why that would happen unless the biological father has placed himself or it's been presented that that biological parent is a threat to that child. Because I haven't seen instances where uh, a biological father has custody and another person that's not related to him just gets custody. Um, those are some extraordinary circumstances. And like Attorney Washington said, we'd have to have a lot of details to be able to examine that. Because on the surface, it sounds to be incredible.
Right, right. And so, what are your thoughts with respect to alimony? what exactly does alimony mean? And then what would constitute, if you know how there will be a calculation of alimony, what would justify some type of alimony payments to a spouse?
So there are a few types of alimony. There's what we call periodic alimony, which is what people generally want when when they hire me. That's when they get paid a certain amount of money for the rest of their life from their spouse. Then we have what we call alimony in gross, which is a specific amount, like say $50,000. Then we have what we call, which may be a combination of alimony and gross, but rehabilitative alimony, where a person, you know, they're recently divorced and they need to get a certain amount of money from their spouse to get themselves sort of like on their feet, to be able to carry on with life. And some of the elements of alimony that I've seen in my practice, the length of the marriage, generally speaking, 10 years. That's not an absolute rule, but in general, if you've been married to a person for at least 10 years, then there's going to be some presumption that there's some interest in the marital estate income. Okay? Then we're going to look at the person that wants alimony. Do they have a need for it? That's another element that is that the court is considers. The third is the person that you want alimony from. Do they have the ability to pay it? For some reason, when people get divorced, they think that multiplication takes place when you have two people that make one person makes $5, the other person makes $5. They get divorced, they want $10 from the other person. That's not how it works. It's a subtraction problem. And then another factor the court considers is the actions of the parties during the marriage. What type of spouse was this person, that caused this marriage to be broken down, and those types of things. Those are just some of the elements that the court looks at. And I can tell you that if the incomes are similar and they are what we a moderate amount, then the chances of getting alimony are going to be on the low end, unless you can show some extraordinary uh, circumstance. Now, if you can contrast that with, like, for example, I have a case I'm working on now where I have a 30-year marriage. This person, my client, is sick, and she's been sick for like 15 years. She hasn't worked for 15 years. She has no income, and her husband makes about $12,000 a year. Well, I would argue that she's going to get some significant alimony in the end. But I don't know if that answers the question, or if Miss Washington wants to add anything.
Yeah, I would just kind of piggyback off of what you said. I think the biggest thing is that the courts are going to look at those main two factors when awarding alimony, which is the need of the person requesting the alimony and the ability of the person that they're requesting it from, their ability to pay. And I agree with you, Attorney Jordan. I get the same kind of thing where it's like I have to break it down where just because you were married a certain amount of time, depending on what your marital status or your financial status was at the time of the marriage, doesn't automatically mean that you're going to get alimony, especially if both parties contributed to the needs of the household. They were equal as far as paying bills and both worked outside of the home. The courts are going to consider all of those factors in one awarding alimony, and then if they award alimony, what that amount is going to be, because the court is not going to award alimony to the detriment of the other spouse. They're not going to do that. And so that's been my experience with the courts in regards to alimony as well.
That's good. Here's a question that came in at 1222. It says, if the other spouse is married multiple times, how do the children from the first marriage receive assets? For example, in the event the biological parents die without a will.
So I'm again, to try and get some context to the question, I have to assume a few things. I'm assuming that we're referring to assets that are going to be given to the kids at the death of their parent, not something that was awarded to them in the divorce decree. Assuming that what I'm saying is correct. If the will hasn't changed, then the gifts to the children uh, should remain the same. But if that person's remarried a bunch of times, there's this thing called the spousal share that will be assessed at the estate. So, for example, the husband has 3 children. He says, my 3 children can have, after his divorce, he says, my 3 children can have all of my assets equally, 33 and a third. Then this husband marries a person for a significant period of time, builds up an asset, a marital estate with that person, doesn't redo their will, and passes away. Well, the will says that everything goes to the children. However, that spouse has the ability to claim a spousal share, which is significant. And I'll just say, without getting into the weeds, the children won't be getting the 33 and a third. I'll just put it that way. It will be significantly less.
Yes, I think you're spot on with that. Here's a little bit of a different angle: is when do you think is ideal for a client to question the fee structure of an attorney that they have engaged? When do you think it is ideal for a client to question the fee structure of an attorney? I know it's sort of like taking a sword and turning it back towards the professional, but I think that there's a segment of the population that sometimes have those questions. But how do you know, or what do you think is ideal? When is that ideal for a client to sit down with the attorney and have questions about the fee structure, whether it's the hourly rate or the contingency fee? What are your thoughts about that? Are you seeing those questions come up in your practice?
Well, I would say that I think the prime time is when you're meeting for possible retainment. I personally like to go through when someone contacts me and wants to retain my services. I actually go through the representation agreement and I break everything down. If it is a retainer type structure, I explain to them that this payment upfront is a retainer for X amount of hours, and then once those hours have been expended, then the hourly rate will then kick in. And then also I let them know that once that, retainer fee has been expended, I personally send them a billing sheet so they can see all of the work done so that there's no, confusion or question about, what it's going to take to resolve or conclude their matter if there's a requirement of additional payment post, you know, the retainer fee being, exhausted at that point. And so I think the best time is when you're meeting with the attorney to possibly retain their services. But at the end of the day, if a client has a question about their bill, I'm more than happy to go over what has been done in the case, what work has been invested, and then how far we have to go to bring their particular legal issue to a conclusion. But again, I would think the best time is, pre-representation. That way there's a clear understanding moving forward as to how it will work, while work on their legal issue on their behalf.
What are
If
your
I
thoughts,
could,
attorney?
if I could add, I agree with 100% with what Attorney Washington said. What I found where the issues come into play is when a person, the case is becoming long,
Mhm.
meaning, you know, a person will hire you, for example, and say, hey, I want to divorce my spouse. And it's going to be an easy case. Don't worry about it, Ezra. It's going to be easy. They're going to sign, yada, yada, yada. So I say, okay, well, this is what you feel be to start out. But just know that your if your spouse doesn't sign and we have to go further and go to trial, it's going to continue to cost you. And as Attorney Washington said, you're going to receive an engagement retainer agreement. It's going to have an hourly rate on it and how it's going to be expended or how it will be refunded in the event that it's not all used. And you will receive a detailed, itemized billing statement to show all the work that's done. And what I found where the questions come is after that divorce has gone on for a year and they're going bickering back and forth over the television and who's gonna get the kid on Easter or who's gonna take the kid for Halloween day, and that's hundreds of dollars an hour to argue about those things. And they say, well, money's not an issue. It's the principle of the matter. It's always money's always the issue when it becomes the issue. So I think it's important that any person that hires a lawyer to make sure you have an engagement retainer agreement that spells out specifically what your obligations are, and that you make sure that you're really litigating things that are important and worth the money that you are agreeing to spend, because that's how it's going to add up if you continue to go on and on and on and on with issues in relate to your case. The more money it's going to cost you.
That's right. One of the things I like to think about is, practicing law is somewhat like a tennis match. You never know when you're going to get a break point. You just know when you put that ball over the net, there's a certain amount of time they have to return that ball back to you, which is typically 30 days, whether it's civil or criminal law you're practicing. So once you get into a high-paced litigation, and because I'm sure all of us are very competitive by nature as professionals, you're just really just driving that ball back across the net as fast as you get it coming to you. And you're right, Attorney Washington. You have to keep up with your billable hours, your times, things like that. But the bar gives lawyers such latitude because other attorneys understand the dynamics by which we work. It's sort of like gladiators. You're just trying to stay alive and keep your case from getting dismissed in some instances, but you're always trying to make sure you're keeping your client apprised of what the fee structure is going in the door on the front end. And sometimes on the back end, that becomes more of a concern. Some agreements, and I'm sure your agreements reflect the same, it's a bifurcated agreement. In other words, it's a two-part agreement. Sometimes you have someone pay a fee up front and a contingency depending on the kind of case when they can't afford a lump sum fee. So you may take a portion of a payment up front, plus you may charge a contingency on the back. If you know the case is very protracted and has a lot of expenses incurred and those types of things, you may structure it that way. And you have to explain that to a client on the front end. And then in other situations, it's a bifurcated fee before litigation, then after litigation. If they escalate, if you have a case where, let's say it's an 18-wheeler case or tractor trailer case, and you send a demand trying to get policy limits, and you think the case is worth policy limits, but they're not willing to pay it, then you turn around and say, well, listen, that's on the A side of the case. It's 33%. But if I have to file a lawsuit, it may go up to 40%, but it's not combined. It's not 33 plus 39%, but it's one or the other because the work was substantially increased or the intensity of the work. In other words, a tennis match becomes more gruesome when you get into litigation, which is where I prefer to practice in the litigation side. I don't like sending demand packages, but my point is that changes the ebb and the flow of the workload. But those are typically just contingency cases because sometimes clients can get heartburn when they see your fee on the back end after you've worked for 3 or 4 years on a case, and they're thinking, well, hey, your amount is more than mine. In some cases, that's not appropriate. Some instances, it is, because just you can't control the numbers because you don't know until the case is over where all the numbers are going to ferret out on paper as it relates to expenses of the case. With hiring experts, I hire experts in cases quite often, and their retainers start out at $5, $10, some cases $25,000, $30,000. And so you have to pay these people, and that money's got to come back to you on the back end of that case once you win that medical malpractice case or case that you try. It's just a very expensive business to litigate cases, but it's very lucrative if you do it the right way and do it over a period of time. So that's a great subject of discussion for clients and attorneys to have these come to Jesus meetings about this money and the expenses and or a bifurcated agreement. So I thought to just make mention of that. I was asked to be sure to point that out, and so I did want to give some distinctions about that. And so I see we have someone posted that money is always an issue. Wow. And so that was statement of Attorney Jordan, and I agree with you to the extent that is. What are your thoughts also with regards to family law, or how do you choose the right lawyer? Is a question that's come up. How do you think clients would consider if you are a good fit for their engagement? And so, I can honestly say I've had situations, and I say, listen, I don't need to be involved in this. I'm going to hire another lawyer to deal with legal matters that I may have professionally or personally. And I look at the fact, okay, I need you to be subtly more aggressive than I am because I'm going to employ your services to ensure things are done in such a way that they're not only effective, but it's not a lot of unnecessary controversy either. And so, how do you think that people should choose their lawyers, and what questions should they ask once the money is explained? The way the question came
I,
up on the screen.
I think the the manner in which you want to communicate and the methods that you want to communicate and how often need to be fleshed out equally as the money issue. Some clients want to be contacted every single day or emailed back every single day. And if the lawyer that you're employing can't meet that obligation, you're going to be disappointed. So you need to ask, hey, how often can I expect to receive communication with you? Do you make phone calls? Do you have office visits? Do we do it by Zoom? Can I email you? For example, those types of things. Like, for example, I have one of my pet peeves, and I'll just say this, just being transparent. I don't like I love you emails. If the emails are more than 4 sentences, call me. I'd rather talk about it because by the time I read 5, 6, 7, 8 paragraphs and trying to reply to it all and make sure it's in the right context, I understood what your question was and the tone of your question, all that. It would be cheaper and more beneficial and more effective for us just to have a phone conversation. So I tried to explain that to my clients when they hire me. Look, if it's a long email, it's better for you to call me. Let's talk about it. And then we can probably answer those questions a lot quicker and more effectively. But if it's short, then that's fine. I'll return your email, your text, or whatever the case may be. I think those are some of the types of questions I would ask a lawyer if I were employing one about for myself.
I agree. I think that is key. I'm gonna kind of flip it a little bit, and with my experience, my when I meet with a client, my rule is honesty and disclosure, and I think integrity for me is key when hiring the right attorney. It's just certain things that I'm just not going to do. It's just certain lines I'm not going to cross. And so when I meet with a client, I explain to them this is how I operate. And I require full disclosure because I can't help you if I don't know everything. I can't formulate the right strategy. I can't study the correct law. And I don't like surprises in court. I can't help you if I find something out in court. At that point you didn't just disclose all of the information, and so at that point I'm at a standstill because I wasn't made aware and I haven't prepared to defend or explain this new information. And so for me, I tell clients, if you're not going to be upfront, if you're not going to be honest, if you're going to withhold information, then I'm probably not for you, because that for me, once I find out that there has been some omission of a pertinent fact, for me, that now creates somewhat of a conflict of interest, because how can I move forward with you if I can't trust you as a client? And vice versa, I'm going to be transparent with my clients. I think that's the thing. I'm going to give you the good, the bad, the ugly of, what your particular situation is and how we can get to a resolve that you are happy with. And so that is kind of what I look at. Is full disclosure, but at the same time, I'm going to give you full disclosure as well, and I'm going to give you what I think are the options available to you regarding your particular circumstances and what the law says in that regard. So, that's kind of how I screen, so to say, when people contact me.
Right. Here's a question that just came in. What if you're living with someone not married and have a child? What happens if you part ways and all the assets, including the house, is in one person's name and they are not the one who pays for any of the bills?
So those are two separate issues. So you have an issue of the child custody visitation type issue that can be handled in the family court. Then you have a property issue that is separate from that because these people aren't married. And if everything's in one person's name, that creates another issue with the property issue that needs to be dealt with in the district court civil side. Uh, if that person has any interest in, I'm not sure how they would. We don't have in common law in this state anymore, so I'm not sure what interest that any of that person would have. So that's really a bifurcated. Those are really a bifurcated issue, in my opinion. Um, so somebody needs to establish their parental rights in regards to the child, and then the assets of the house that's that's in one person's name. They're responsible for paying the debts that are in their name. I mean, I guess there could be some lawsuit to be filed to say this person is culpable for some of these bills in some way. I'm not sure what that would be from the question, but in general, he or she who signs the bills, they have to pay the bills.
Yeah, I would just piggyback to say that unfortunately, you're not afforded a lot of protections outside of a marriage when you cohabitate. And one person, name is on all of the assets, and the other person might pay the bills. It makes it a little sticky for the courts to kind of address those issues because unfortunately, again, there you just aren't afforded a lot of protections when you're not married. And I would say in regards to the child, as Attorney Jordan said, that's something that definitely would have to be filed in family court. Paternity will have to be established. And then in regards to what those issues are with the child, as I stated earlier, you're going to have a petition for support, and then you're going to have a separate petition in regards to custody or visitation. Or you could just do it all in one, depending on who brings the action up front. But that's something to definitely be addressed in family court in regards to the child, and in regards to the assets, as Attorney Jordan said, that's in a separate court. And you know, it's just the facts make the law muddy. I put it that way. The law is clear. It's the facts that kind of muddy it up. And so the judge and the courts are going to have to kind of go through what you all have kind of built together outside of the parameters of a marriage, and address those accordingly.
Right. And so Attorney Jordan touched on this earlier, but I do think it bears to be reemphasized that as of January 2020, Alabama no longer recognizes common law marriage in the state. And so people prior to January of 2020, if my memory serves me correct, they could proclaim or claim that they were common law married. And as a result of that, they would actually have to go through an actual legal divorce. Is that your understanding, Attorney Watson?
Hmm.
Yes. And so that's where they hold themselves out in the public as being husband and wife, and and they would have joint accounts, live in the same property, things like that. So now that Alabama is no longer a common law marriage state, hopefully that will clarify a lot of rights of what people do versus what they do not have as it relates to assets that were garnered during that time by which they were domestically residing and not under a covenant of marriage. And so our time is coming to a close, but I think we have one or two other moments that we can maybe answer a few more questions before we're done for today. I'm just so delighted to participate with this very esteemed panel of attorneys to engage these questions. I think this is very paramount in our world to have forums like this available for the public so they can get questions answered, because it will make a difference in the outcome of how individuals, you know, outside of the professional world, even those in the professional world, make decisions and how they make moves in relationships to others. And so, with that, allow me to ask you this question too. With regards to alimony, would I'm asking the question here? Would a remarriage terminate an obligation for alimony?
Depends on who's receiving the alimony and who is paying the alimony. If you're ordered to pay alimony and you get remarried, you can always, depending on the type of alimony that you are ordered to pay, particularly if it's periodic. Um, and I've had a case like this, so that's why I'm from my own personal experience. You can request or you can file to modify, but if the remarriage doesn't necessarily affect your ability to pay, then it may not be terminated or modified or lowered. If you are receiving alimony and you get remarried, and you're receiving periodic alimony, then it will more than likely terminate the alimony that you are receiving from your ex-spouse. And so, again, it just depends on if you're paying or if you are receiving the alimony, whether or not it terminates in regards to remarriage.
And it's truly tough. With regards to bankruptcy, and I'll dovetail back into the statement Attorney Ezra Jordan made earlier about a Chapter 7 versus a Chapter 13. Do you happen to know what ratio is more common among different demographics as to who file which type of bankruptcy more often than not? Or,
Well,
you know, have you ever read any
uh,
statistics that speaks to that?
I think you mean demographic in terms of income, or are we talking race or what?
Both.
Well, it used to be the case that we didn't file, when I say we, I'm talking about African American, that we didn't file a lot of Chapter 7s. We were mostly in debtors court. But the way that the bankruptcy code is set up now, and the more that our median income increases and the amount of debt we have to the amount of opportunity we have to put ourselves in debt, uh, we are filing Chapter 7 more than 13 when we can. When I when I'm doing a bankruptcy for a person, everybody almost wants to file a Chapter 7. Okay? Chapter 13 is usually by default because there's just no other way to maintain that asset. So I would say that the majority of us are filing Chapter 7s, um, more so than Chapter 13s. But I think if I'm not mistaken, the last statistics that I saw, we're not filing bankruptcy at a higher rate than they are, than other races are.
You said that we're not.
I don't think so. If the stat that I remember is correct, but I think the more important correlation to that is the increase in median income and the opportunity to be in debt. So the more money we make, the more opportunity we have to be in debt, which makes Chapter 7 uh, a better opportunity for a person that wants to raise that debt. For example, if you're not making uh, above the median income in this state, then you're probably not likely to be in $100,000 worth of credit card debt because you probably can't get access to that type of credit. Whereas a person that makes the median income and above, they probably will be eligible to have 2 and 3 car notes and a bunch of credit cards and all these other types of things. And those are the people, when those things get out of hand, are the likely candidates to seek for Chapter 7 bankruptcy protection.
Mhm. Well, very good. Well, listen, I have truly enjoyed myself over these last 3 days. 12 noon to participate in this uh, legal Q&A forum, and I'm just so delighted that the two of you have taken the opportunity to participate in this forum today. There's one other question we're going to address, and it is, what is a median income? This question just came in just a few moments ago.
I want to say it's $36,000 for a family of four. I think,
It's like 34.6, right?
yeah, something like that. Yeah,
In the state of Alabama, and in the world, if you make $100,000 a year, you're in the top 2% of the wealthiest people in the world. The median household income in the United States and even in Alabama is around 33, 34.5. And like you said, that's with a family of four. I mean, that's pretty tough. I heard you mention earlier that in some instances someone was making a spouse was not working and the other spouse was making $12,000 annually. Is that what I understood you to say? And was being
Yes, sir. $12,000 a month.
a month. Pardon me. That's 144,000 annually. Excuse me. Uh, and so even with that, I mean, with inflation now soaring, the Feds are trying to get inflation down to 2% right now. It's well above 2%. But it takes income to have a very sufficient quality of life, and so we're definitely praying for everyone to be mindful of how they steward their resources and actually engage in relationships and do things that are building equity and value and not just splurging on unnecessary things that do not build a good quality and stable life. And so, with that having been said, listen, I want to thank the two of you for participating. I also want to thank um, Elder Oscar Matthews, who does a wonderful job of supporting the IT platform of NLIM and CRCC. And then hats off, every hat off to Pastor Judith Matthews, who does a phenomenal job in making sure that these types of forums are active and viable and that they are consistent. And she always does everything with the spirit of excellence. I've truly admired that about her and the entire Matthews family over the years we've been involved in this ministry. Also, I would like to thank our viewers who have spent this time with us and participated by way of asking questions. And I pray and hope that you've truly gotten something out of this. And before I close, I want to also extend a very strong word of encouragement to our pastor and that he continues to do what God has called him to do. And he's taken the sensitivity to make sure that we're giving good content out every time this ministry puts forth an effort. It's always with the spirit of excellence. And I truly appreciated that about him as a leader. And we just want to thank everyone for taking the time out today and participating. Hope you have a wonderful weekend and a very, very safe spring break that is coming up. And remember, if any of you have any questions, please feel free to reach out to Attorney Washington, Attorney Edward Jordan, reach out to Sam Wiggins, who participated earlier this week. And do not forget to support Shante Brown for Judge. She's a wonderful person, very knowledgeable, and very sensitive to all the issues we mentioned today. And I think she'll be a great addition to the judiciary in the Bessemer Cutoff, which is the area where our ministry is and where some of us may live, work, and play. So we want to encourage her to continue to soar to new heights. And with that having been said, my name is Antonio Sterling. I'm your host, and I want to thank you for participating. And we will see you next time. Preferably, we'll do this on a more consistent basis. But till next time, peace and be safe, and God bless you.
Thank you, everyone. I appreciate it.
Yeah.